Hello, ladies and gentlemen. My name is Tim Gagan, and I'm a lawyer in Quebec. What you are going to be watching today is for legal information purpose only. It does not constitute a legal advice. If you have a real case, if you need a real legal advice, please contact your lawyer. If you need more information, here are several useful links. If you need a lawyer and you don't have a lawyer, please contact the Law Society of Quebec, Barreau de Quebec, and they will help you to find one. When we understood that the defect is really latent, in the sense that good, diligent visual inspection could not reveal that, and probably an inspector was hired and made a report, and yet nothing was visible, nothing was apparent, there was no indication of a problem. The question is, was it really a defect? In a sense, was it a grave, like serious, like really bad defect? So you see there are two words, latent, defect. Both should be proven. It was latent, it was a defect. So if there is a minor scratch that would not affect the usability of the property you have bought, and any appraiser would say that it would not diminish the price, the cost of the property on the market, then it's not that much grave, and again, there is no defect in the eyes of the law, at least. If it's easy to remove, if it's easy to repair, if it's only cosmetic, if it's mostly about decorations and not about the essential properties of the house, of the building, of the condo you have bought. So you bought it for living, it's livable. You bought it for comfortable living, it's comfortable. Decorative value, it's of a less matter. So the question, and again, you see, it's sort of not so objective, though, of course, you could hire an expert. The other party could hire an expert. You could show the judge the pictures. You could explain how is this particular crack, even though there is no floods, for example, is bad to you because you, for example, have a little baby and the temperature in winter goes below a certain level, and it makes it maybe livable for an adult, but dangerous for a little baby, and so on and so on. So there is a subjective point here, so like circumstantial point here, but still, the judge, if you're ever there before a judge, the judge should understand that there is something to talk about. There is a defect, like something serious, something real. Usually, the major question is about the price. Like, if the defect was known, if the extent of the defect was known, would the price be lower, or maybe the purchase would not be even concluded if it was known. If that's the case, then the defect is considered serious, is considered grave, well, usually. If you can prove that as a buyer, because it's on you to prove the latent part and prove the defect part, then again, you might claim the cost of repairs, or you might claim some difference between the value you paid and actual market value as damages from the seller, if it's practicable. So you see, usually, if you even get that, there is always a question of practicability. Because to prove whatever you need to prove, very often you have to hire an expert, an appraiser, collect other evidence about the comparative value of the houses, or say similar buildings in the area in the similar circumstances. So it will be some kind of a hassle. And if you see the reason to go there, then, well, you would know what to do, what to prepare, what to collect. But sometimes, if the seriousness of the defect does not justify all this problem, like, to go around, then maybe the defect is not that much serious after all. When the court or an expert tries to evaluate what would be the damages, what would be the money to be paid for it. Usually the idea is all about evaluation and provable evaluation, preferably. Like what would be the cost of repairs? So obtain an estimate from some company, from some construction company or some private contractor with a cost, with an approximate cost, like how much will it be. Then add taxes and remember to add something unpredictable. Yeah, because usually when you see the original estimate and then later on you see the real cost of reparation, something between 20 to 30% should be added. And well, if you cannot prove that to the judge, then most probably you will receive less than you actually should. The time for repairs, and if in the meantime you could still use the immovable property you have bought or not. Because one thing is that the garage door needs to be repaired, but you still can move in with all your family, with all your property. Or if the whole building, because of some major problem in the basement or about some dangerous molding or some infestation, the whole building is potentially dangerous for those, or at least unpleasant significantly, for those who are expected to be living there, then it's also kind of a damage because you need to spend money to live somewhere else. You'll have to prove that. And if that kind of delay does cause you any kind of, again, additional loss, maybe economic loss or whatever else could it be, if you can prove that, okay, it adds to the gravity of the defect. Whatever we are talking about, that's very important. If you feel that's a defect, that something is a defect, if you feel that it's grave, that's not enough. If your neighbor agrees with you, if your relative agrees with you, that's not enough. You need independent assessment most of the time. You need some paperwork to be done to prove your point in court. Because if you only get before a judge with "I say so, he says so," the chances are not so good. Collecting evidence, again, it's important, and it adds to the cost of the defect, apparently. And very often, it's not something that you could add to the actual cost. It's only something that you should think of before even getting there.